Good morning, everyone. Happy Monday. Join Jackie on Mondays for short snippets of legal information. Today, we are talking about doing your will after you've separated and why it's important. So, you may have done a will while you were married or in your relationship, particularly if you've had children. And being separated does not invalidate that will. So that will is still valid if you've separated. And that will probably leaves everything to your now ex-spouse. And then a lot of people also separate and then never divorce. And so it could be years and years in between their separation. They've done a financial settlement. They've got on with their lives. They may even be with a new partner. They just haven't had the divorce. And if you haven't done a new will since the one you did with your ex, that will is still valid. And again, it probably leaves everything to your ex-spouse, even though you've both now done your financial settlement and you've both moved on in your lives. So divorce, once you finally do end up divorcing after a separation, which is not absolutely necessary, but if you do, divorce does invalidate a will only so far as that person is involved. So they are then treated as if they were dead in your will. And so any will that you had prior, which mentioned that person, now excludes that person, but the will is still valid. So for example, if you left everything to your ex-spouse and then equally to your children, you've now divorced your ex-spouse, everything still goes equally to your children under that situation. But of course, if you haven't divorced and you just separated, that will would be still valid and everything would go to your spouse, even though you've moved on in life. So super important to do a will. The other situation as well might be that you were in a de facto or marriage and you didn't actually ever do a will and you've now separated. So for 5 years after that relationship has ended, they are still considered your spouse or de facto for the purposes of intestacy law, right? So even if you've done your financial settlement and all those time periods for having your financial settlement are done and finished, which is usually 2 years in family law, it's 5 years in intestacy. So you may have separated from your ex-spouse, done your settlement, and then die within another 2 years of that. And if you haven't had a will at all, that ex-spouse is still considered your spouse for the laws of intestacy. So it's not great that the laws of intestacy don't match the family law laws, but it is what it is. And unfortunately, what do they say? That ignorance is no excuse. So here I am telling you, if you've separated, do a will. Even if it's nice and simple, just redoing it to make sure everything goes to your kids equally or however you want it. Or if you do still want it to go to that person, you can still reconfirm it. Otherwise, yes, do one because it can leave a sticky situation, particularly if you have a new spouse, of course. So that being said, if you know of anyone in a situation that I've just spoken about, please tag their name in the comments below so they see this, or by all means share it with them privately on Messenger so it's not public on their Facebook feed. And remember that this video, while live, will be saved onto the page. We've got a big library of videos there. It's a great place to start if you, a family or friends have a legal challenge. Go there, see if we've done a video on it. And if we haven't, by all means, reach out to us, ask a question. I could do the answer for you in a short snippet like this to at least get you started. Otherwise, I hope you have a really great week and I'll catch you next week.